Hi guys, welcome back to my channel, and if you're new here, welcome. Igama ngu AsandaNtini, and welcome to my channel, and welcome. Can tell by the title of this video, today we are discussing an interesting legal topic, which I believe if you are a candidate attorney who is doing articles, it's very hot, as you can see. Like, I'm shimmering, I'm not sweating, I'm shimmering because I have a lot of sunscreen on, so I can't control how I look right now. I always shimmer when it's this sunny. Anyways, yeah, back to why we're here to discuss a plea. I am an admitted and practicing attorney in South Africa, and recently back in the practicing role. I still don't know if they've put me back in, but as I've indicated in my previous video, they have sent me confirmation that I am back in the practicing role. Anyways, be that as it may, I just wanted to share with you guys, especially this video is specifically made for a candidate attorney, a junior practitioner, as I am still a junior. If you've not done a plea before, this video might be very helpful, or if you just want to refresh yourself, as I have had to do, as I've recently gotten back into practice after leaving practice for about a year and a half. I had to refresh myself. Gonde, what is a plea? Because I actually had to do one in the very first week when I got back. So interesting times. Anyways, if you are a candidate attorney in a practice that does general litigation, including criminal practice, you are likely to do a plea at some point, especially if it's crimes that do qualify for minimum option of a fine. So you're likely to do that as a candidate attorney. Please be advised that if you are watching this video thinking it's legal advice, it's not. I do not offer advice here. This is just commentary and information specifically made for practitioners and people that are doing just want to learn more about law. It's not legal advice. If you are looking for legal advice, please go and consult with a legal practitioner. What exactly are you doing if you are pleading? I do have notes, so yeah. By electing to maybe, like, let's start with the admission fine. If you are paying an admission of guilt fine at the police station, the police or the peace officer or the police officer is required to explain to you what does it actually mean to pay that fine, because it is an admission of guilt and it's likely to show up in your fingerprints if ever you are now arrested for a serious crime and you're asked, do you have previous convictions? Like, no, I don't. Turns out you do. And then maybe you've already submitted that you don't have previous convictions, and it becomes an issue when they're granting you bail. They say you're lying on oath. It becomes such a mess. Anyways, be that as it may, those rights need to be explained to you, because an admission of guilt almost weighs the same as it weighs an admission of guilt that you do under Section 112 of the Criminal Procedure Act in court. All right. So what firstly happens with an admission of guilt, or if you are admitting guilty in court, is that you now waive your right to confront your accusers, the right to testify if you need it, to testify along the case. You could testify, like, to testify against the evidence that's proven. You could testify on your mitigating factors. You could testify on the crime itself. And you also waive your right to call witnesses that prove contrary to the charge. You could bring witnesses that are maybe proving you in your mitigating factors or whatever it is that you wanna. And then if you paid a right of admission, an admission of guilt fine at the police station, you now also even waive your right to legal representation. All right, so That's what it does. When you are now pleading as a practitioner, when you are consulting and realizing maybe you're getting this client after having gotten copies of the charge sheet, and they were like, actually, I wanna do a plea. I wanna plead on this crime. And then you ask them what happened, and then you realize that actually the docket itself proves all of these crimes that they have done, and what they are telling you also proves that. So they are admitting, when you are now preparing your admission of guilt statement or whatever it is that you are preparing, you are admitting that the person, it's an admission by the accused of each of the essential allegations to the charge, not admitting to any other thing but the essential parts. For example, an essential part in housebreaking, without having proper right to do so. So that's admitting to breaking in. All right, meaning that you are no longer now at issue with the prosecution, with what they are bringing to court. You have no issue with what they are bringing. The only so you no longer want them to prove, Uguti, how did you commit these elements and how did it happen? Because it's fruitless to go on trial. Like, I don't know of an attorney or practitioner that would want to go on trial when they know that actually all of the elements have actually been committed. There's no way of winning this. I don't know a practitioner that goes on trial when they know Uguti, unless those dodgy practitioners that you'll be hiring there who just do things according to your instructions. Anyway, so then this is what happens in court. So you've now prepared your statement. You are now going to court. Alana, it is so hot. So okay, you've now prepared your statement. You've signed the statement. The accused has signed the statement. You are now at court. This is what happens at court on the day of the plea. The prosecutor will call the matter, state who are the appearances, the interpreter, if any, and then will also state the date, everything, call, and then the first thing that they're going to do pertaining to the matter is that they will read the charge. Read the charge as it is, charged with theft, that on the day of maybe the 18th day of November, you were found guilty of, you stole this, and that which belonged to this particular person. Or on this particular day, you broke into the house of this at this time. Then it's interpreted. Then the court being the presiding officer, will then ask the accused, how do you plead? Then the person will say, I plead guilty, because we are speaking about the plea of guilt. And then after they've done that, they will then ask you as the legal practitioner if this is accordance to the instructions you were given. Like, confirm, yes, this is in accordance with the instructions that were given to me. May I have then prepared a statement in terms of, if you've prepared the statement in terms of section 112 subsection 2 of the Criminal Procedure Act, if that's the statement you've prepared. For the purposes of this video, I'm going to speak of the statement. You prepared the statement. I'm speaking of the statement. You prepared the statement, and then you read it, and then you say, you've prepared the statement, may I read it to the record? Because you must ask for leave to do whatever it is in court. You don't just do, yes, and then you may read it to the record. You read the statement as it is. You don't add or subtract anything. You read the statement as it is, and the statement will be confirming all of the essential elements of committing the crime. That's what you're going to be doing. And then once it's read, the prosecution will be asked, do they accept the statement as pleaded? Yes, they accept that. Then the presiding officer will then say, okay, I found you guilty as you've pleaded. The court may not, after the prosecution has accepted the plea, say, actually, I find that this is not a plea. I mean, this is not a guilty plea, change the plea, whatever, because they are now interfering with the independence of the prosecution. But when a person appears for themselves independently, like these people that think they know law more than anyone in this world, that want to plead for themselves, I don't know why y'all do that when there's legal aid available. Anyways, the court has the right then, in terms of section 113 of the CPA, to say, okay, actually, I think you've pleaded, but you've not pleaded guilty to the charge that you've been given. So I'm correcting your plea as of not guilty. The prosecution now has the duty to prove the charge. That's the only time. Otherwise, it's irregular for a court, after the prosecution accepted the plea, to now say, no, I don't accept this. Thereafter, they're going to now, the prosecution will thereafter read the previous convictions of your accused, if they have any, as accordance to the SAP 69s. If there's any, okay. If there's none, perfect, even better. Thereafter that, the court will then say, defense, then you are now going to address the court. What are you addressing the court on? You are now giving the court mitigating factors of the accused, and then you are also addressing the court on sentencing. So first thing you say on mitigation of sentence, you like to put it to the court. Things that we usually state are that they didn't waste the court's time. Hopefully they didn't waste the court's time. They've pleaded guilty to the charge. They've done this and that. They don't have previous convictions. You state their personal circumstances. Maybe this person is a father, is a mother. All of those things you stated to the record. And then after that, the prosecution will now give aggravating factors. The fact that maybe the crime is prevalent in the jurisdiction, because most of the time, crimes that are prosecuted are crimes that are really prevalent in the jurisdiction. Like in our jurisdiction, theft and housebreaking are very prevalent. Those two things are very prevalent. So the prosecution will now give that, will give their desired sentence as well. And then you also would give your desired sentence. Usually in crimes like that, it usually has an option of a fine. Could also ask for a wholly suspended sentence. Prosecution, if you've asked for a wholly suspended sentence, likely they'll say maybe direct imprisonment, or that the sentence may not be suspended, whatever the case might be. So basically it is you saying good things for your accused. The prosecution is saying good things for them, because they want prosecution to happen. They want a sentence to be as good for justice in the same sense that you wanted to be as good for justice of your client. They also wanted to be as good for the justice of their client, who is the complainant. You see, who's the state, who's the complainant. So that's what happens during this time. And then final thing that happens is then the court will then decide on the sentence, impose the sentence, and they're going to take the fingerprints of once they've imposed the sentence, are you guilty, and I'm charging you this amount of time, then you'll say, as the court pleases. You have to say that, okay? Then if your client was charged with the crime of that has to do with an element of dishonesty, you need to remember to address the issue of them having their right to a firearm license not suspended or thingy. So you need to address that. Maybe if it's a young person, they might have potential of getting a job as a security at some point. If their now right is taken away from them, you raise those things, because prosecution, if you don't raise it, they'll just raise it, and then if you didn't put anything for court to work with, unfortunately the court cannot maramuto put things that you didn't say. That's the thing. And then remember to relax when you're doing your plea. Write things down. In as much as it's some people say if your attorney wrote things down, you're not confident in them. Mina, I like ticking off things as I'm saying them. Good, see, this is what I'm saying. This is what I'm saying. Or draw dots. Like sometimes I say accused, this. I write alphabet and write like something that's a square. So as I'm speaking, I'm drawing a square. It's okay, I've now completed a square. Whatever it is that works for you, and good luck on your plea. I hope it goes well. I hope uzongashisela right now, guys. the things I'm doing for y'all guys. I could actually be playing my music, listening to, enjoying the fan, but I'm here speaking to you guys, helping you prepare for your plea. And please remember that none of my videos are legal advice if you are watching this as your legal advice. And if you want to not plead and go to trial, you are an accused, thinking you can go to trial because you don't want to plead guilty and all the elements are proven in the courts, in the prosecutor's docket, good luck, my friend. Thank you so much. We'll be seeing you on my next video. Don't forget to like, comment, and subscribe. Bye.